In this video, I'm going to talk to you about the crime of reckless driving in the state of Arizona. Hi, I'm Javiar, Alatorre, owner-director of Alatorre Law, and I help people fight for their freedom and protect their future. Let's get on with the video. Okay, so what is reckless driving? ARS 28-693 defines it as driving a vehicle in reckless disregard for the safety of persons or property. Reckless driving, right? It's kind of like it defines it with the same word, right? So it's kind of vague. It is a vague statute, but sometimes we can use that vagueness in our advantage, right? So I'll explain that a little bit later. But let's start with, what is reckless disregard? Well, it's really weird. It's really vague as well. So I'm just going to read it to you. But it says basically, reckless disregard means that the defendant is aware and consciously disregards a substantial and unjustifiable risk that a result will occur, or that the circumstance exists. This risk must be of such a nature and degree that disregard of such a risk constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. That's much help, huh? Yeah, it's still kind of vague and weird. It's like, because, I mean, what result? What circumstances, right? I mean, what is the risk, right? There's the risk of what? Of safety or not safety? It's still vague, right? So there's not a lot of case law out there, but there's an old case, which is based on a previous version of the statute, but it's the only one that kind of defines it. And I'm not sure if it's still good law, but it seems like everybody just kind of accepts it, something like that. It says that it's driving in a manner that creates an unreasonable risk of harm and involves a high degree of probability that such will be a result. That to me sounds more like endangerment, which is a separate crime. That's how the court said it at that point. So I don't know if that still will be upheld because it's based on an old statute. But like I said, it seems like everybody accepts that that's still the case. Now, one of the things that there is also out there is a case that says that just engaging in dangerous conduct, like dangerous driving behavior, is not enough. It has to be more than that. So you have to be aware of a risk, accept it, and act knowing that the risk is highly probable that it would occur. That's why we call it a gross deviation from what a reasonable person would do, right? It's just not, driving, and dangerously is not enough. Now that we kind of, to a degree, know what it is, okay, so let's talk about potential punishment for reckless driving. So on a first offense, no priors, it's a class 2 misdemeanor. It has 4 months maximum jail time, $750 fine, and up to 2 years probation. These are the maximums, okay? You will get 8 points on your driver's license, so you'll probably have to do traffic survival school to avoid suspension. A judge may order a suspension of your driver's license, and if so, the suspension will be for no more than 90 days. Now, if within 2 years prior to the conviction, you have a conviction for reckless driving, driving on the wrong way, which is a civil offense, by the way, racing, DUI, negligent homicide, or manslaughter with a vehicle, then it's a class 1 misdemeanor, which means that the maximum penalty now is 6 months in jail, up to $2,500 fine, and up to 3 years probation. There's a mandatory 20 days jail on this one. If you have that prior within 24 months, it's mandatory 20 days jail. You might get some kind of work release or something, but you're going to jail mandatory. Minimum. Then the judge may order you to surrender your driver's license. If the judge orders that, the suspension will be for 1 year, but you can get a restrictive driving permit after 45 days. What are examples of reckless driving? It's kind of very subjective. Cops will probably say everything is reckless driving, right? But there might be behavior, like it says, the behavior must constitute a gross deviation from the standard of conduct of a reasonable person. So I've seen it commonly charged in racing. When you have somebody that gets charged with racing, well, they'll probably attack on the reckless driving, aggressive driving. I've seen it attacked onto that. I mean, maybe somebody's brake checking people or something like that. That could be considered reckless driving. It's a usual negotiated plea on a DUI, like they drop it down to a reckless. Anytime a cop charges you with multiple violations, it might be one of them because, cops just have a very subjective and special view of it. But the best example I can come up with, when I was thinking about this, if you saw that movie, Scent of a Woman, Pacino's character is blind and they test out a Ferrari and he's driving it, a blind man is driving, and his buddy Charlie sitting in the co-pilot, he's telling me, left, right, stop, go, right? That clearly is reckless driving at the very least, if nothing more. And then also Charlie would be an accessory, so he would also be a co-principal there probably. So that's the best examples I could give you of reckless driving. But it's a very vague statute, so it just depends on who's looking at it and how they're looking at it. Now, what are the defenses? First of all, before defenses, do we have a way to make it go away with a class or something like usual, traffic offenses? The answer is probably not. Diversion is not available. So the classic diversion for any traffic offense is a defensive driving school. So you take a defensive driving school and then they dismiss the charge. That happens in mostly all civil traffic offenses and criminal speeding, but not for this one. Okay, at least not for formal diversion. There is such a thing as informal diversion. So formal diversion is you do it formally in paper, you present the paper to the court is part of the whole thing, and after you provide proof of completion to the court dismisses the charge. That is not available on this one, but informal diversion could be available depending on the facts of your case, the court, the prosecutor, maybe some mitigation information. I remember when I was a prosecutor, I would do informal diversion on certain cases. If there were like mitigators that told me, okay, that's not available, but I can use my discretion for the benefit of this person because there's issues about this particular person that require some consideration and discretion on my part, right? So you need the right prosecutor and the right facts. But if you can, informal diversion is if your lawyer and the prosecutor come to an agreement, or you if you don't have a lawyer, and then what happens is the prosecutor says, okay, you need to do all these things, and when you complete them, I'll dismiss it on prosecutorial discretion. Or he can offer you a plea to a civil charge or something like that. It just depends on the prosecutor. And there's some statutes that limit what he can and can't do, but prosecutorial discretion is kind of wide there. So, the prosecutor just dismiss it on prosecutorial discretion, and that's it. Now, let's assume you don't get a good prosecutor here, or the facts are pretty bad, and you can't get diversion. So you have to defend the case. So sometimes prosecutors will just say, well, here's a plea to reckless driving, and that's your only charge. Why would you do that? No, you wouldn't take that. You don't take a plea that doesn't get you anything that you can't get on your own, right? If you want to know more about when to take a plea, what's a good plea, bad plea, I'm going to put a video here on the card where I actually talk about, plea or trial, what you need to consider in making that decision. If you have questions about that, go check it out. Going back to this video, let's assume the plea's bad, right? They just want you to plead straight up. Why would you? If they're offering you a plea to the same charge, might as well go to trial, right? So that's what we do, right? We set it for trial. Right? Now, the great thing about reckless driving is you get a jury on this case, okay? There's very few misdemeanors that get jury, but reckless driving is one of them. So that's a great option because it's a lot better to have regular people who are not lawyers, who are not judges or prosecutors or defense attorneys or whatever, to look at the facts and decide the facts like a regular human being would do, particularly because the standard here is that of a reasonable, prudent person, right? They have to judge what is a gross deviation of what a reasonable person would do. Who better than a normal, regular person? So that's a great option. So you always want a jury trial when you can get it. You go to trial, you get that jury trial, right? So before you get to trial, though, before you go to trial, you might consider challenging probable cause, right? The probable cause determination, because the cop made a probable cause determination when he charged you. So you could potentially attempt to challenge that determination. Probable cause says, no, that's not enough. That's even if everything he says is correct, there is no probable cause that I committed the reckless driving. So therefore, this case must be dismissed, right? Even it's kind of like a there is no crime kind of thing, right? Even if I assume all those things, there is no crime, right? That's one thing you can potentially try. You need the right set of facts for that, but that's a potential option. If not, then you set it for trial and you get a jury, right? You demand your jury trial and you force the state to prove their case beyond reasonable doubt. A trial, well, they have to prove beyond reasonable doubt that your behavior was reckless, right? That you assumed this unjustifiable risk and that risk was imminent and that it's a gross deviation from what normal people would do. So for example, if all they got you is going really fast, well, that you might be speeding, but is that reckless driving? You might be even taking a risk that's not justifiable, but it's a substantial, and more importantly, is it a gross deviation of the standard of conduct? Because most people drive too fast. So it might be a deviation, but not gross. It's a common deviation, right? So that's kind of how you attack it. And you usually want to appeal to the jury's reasonableness and sense of fairness and common sense to determine and adjudge the actual things that you did, whether they rise to the level of that gross deviation, whether that risk was substantial and unjustifiable, or whether it was the run-of-the-mill just bad decision. So that's kind of where you go. And that's where a jury really helps. In my firm, we get a reckless driving case. Well, the first thing we do is we get all the evidence, the police reports and all that, body cam footage and all that. And then, we'll talk to our client, figure out what happened. If there's a dash cam, it's rare, but sometimes we have dash cams, and then we look at that too. And then we analyze the facts and we talk to the prosecutor. We do check first if there's a potential of an informal diversion, or if the prosecutor will offer a lesser charge, maybe a civil plea. And if none of those are available, then we prepare for trial. We get all the evidence, we file motions to preclude, we follow these things. And during that process, sometimes we get a better plea, we get some kind of options, right? I've had cases where right before we get to trial, they just decide to dismiss it because it's not worth their time. That is at prosecutorial discretion. They can do what they want to, right? Once they start reviewing the case, once they start looking at the evidence and seeing the motions that we're filing and how we're challenging the case, they'll start saying, oh, well, you know what? Because prosecutors do have a duty to look at their case and see if they can really win, and they have to be reasonable about it. And if they decide, no, I can't win this, they should dismiss. And sometimes once we force that issue, they'll dismiss, or maybe they'll offer you something better, right? It just depends. But we need to review the case and work it and investigate the facts and challenge all the evidence to present a good defense. And that is the crime of reckless driving in the state of Arizona. I hope this video has been helpful to you. If you or somebody you care about is facing criminal charges, my contact information is in the description down below. Feel free to give us a call or book an appointment. We'll give you a free consultation, see if we can help you out. See you in the next video.